Hi, this is Curt, and welcome to another edition of Fire Law Roundup.
Newark, just so people understand, is a very busy area, very busy department. The city of Newark is very industrial, very commercial. So this is a busy department. And this is probably not unique, but in New Jersey and New York, military service, like around the country, right, is significant. So here we have the Appellate Division in New Jersey, so probably the second highest court in New Jersey, has said that the city of Newark has to comply with an arbitrator's ruling, and the arbitrator ruled that the city has to continue military benefits. Now, I'm going to make this shorter, and you may want to expand it, but the short is that there was an executive order which required military leave and paid military leave, and then the mayor unilaterally rescinds it after a very long time of having it enforced. This was put in place after 9/11, right? So Then you get to 2015, and they rescind, the mayor unilaterally, without discussing with the union, rescinds his executive order. Now, this is a really interesting issue for the unions out there, right? Because you have something that may not have been bargained for or negotiated first, right? It came from an executive order saying that the city is going to provide firefighters who are in the military with military differential pay and the continuation of health benefits and pension contributions, all while on leave. So the mayor says, well, look, a mayor put it in, a mayor can take it out. The arbitrator listens and ultimately rules that these were put in place for so long and lasted for so long. They're now, if I'm saying this right, Curt, and please correct me, they're now become a subject of mandatory negotiation, right? You can't just take this benefit away when it has been in place for so many years, which I think is a really interesting issue. The court then, it gets appealed to a court, right? And the court, basically all they're saying is, listen, the arbitrator's right. We're not disturbing his ruling, and we're relying on the arbitrator. And I don't know if the court addressed the law in full of, hey, if you have a benefit for so long, does it just become a mandatory subject of negotiation before you could take it away?
It's a little more kind of, Brad, you said the magic word. You said that this is interesting. I wrote my law school thesis on this issue, not specifically military, but the bargainability, the scope of collective bargaining for firefighters that's what I studied for my law school thesis. And so it's an issue close to my heart. It's one that I followed quite a bit. But the official lingo for what's bargainable is wages, hours, and other terms and conditions of employment. We put quotation marks around that. Wages, hours, and other terms and conditions of employment. So now you get into all sorts of things like, is healthcare wages, hours, and other terms and conditions of employment? Is staffing? Is the number of apparatus? Is shift schedules and all those different things? But the point here that one of the exceptions to scope of collective bargaining for firefighters are things that fall under a management prerogative. And what the city was arguing was that this was a management prerogative because it was something that the mayor in 2001, it was a prior administration, by the way, but the mayor in 2001 decided to do on his own. And now we have a later mayor, 14 years later, wanting to change it. And they said because it was really something that he chose to do in 2001, it was something, and it was one of the arguments they made was that because the mayor didn't have to do it in 2001, he wasn't bound by it, that he chose to do it. It was a management prerogative, that it's just a management prerogative to get rid of it. And the court said not so fast, or the arbitrator said not so fast.
Arbitrator, yep.
Right. We have to look at whether or not it fits within the definition, regardless of how it got there. Does it fit within the definition of wages, hours, and other terms and conditions of employment? And the arbitrator also looked deeply at this, looked at the fact that over the intervening years, from time to time, there would be issues that would come up. For example, someone would not get one of the benefits they were supposed to get. So the union would go meet with the city and they'd address it. So there was bargaining over it It just wasn't incorporated into the collective bargaining agreement. But the parties, in fact, negotiated and discussed various aspects of this particular order. There's also the issue of past practice and whether or not something becomes part of the mandatory subject for bargaining because it's a past practice and it can't be unilaterally changed. So that was also discussed. And for people who are interested in any of those things that I just talked about, read the decision, read the court's ruling, because they go through a lot of this in detail, and it's slightly different in each state. New Jersey actually has a fairly limited scope of collective bargaining compared to many other states, but still the arbitrator ruled that this was appropriate for bargaining, and that the city, even though it might have been a management prerogative that brought it into the collective bargaining process, it was not something that management could unilaterally change on their own. So
yeah, and I think this has broader impacts because, for example, when I was fire chief, and I never wanted to wear my fire chief lawyer hat, but neither
you
side
can't take the lawyer part of it out, though. You could try.
Can't take the lawyer part out of it, right? Yeah, exactly. But the union, neither the union nor the employer, in my case, a village, ever wanted to open up the contract, right? So we always entered into memorandums of understanding. So we didn't affix anything. So I look at the executive order akin to one of these memorandums of understanding. And I know there are cases that say memorandums of understanding you can be bound by just because you didn't want to open the contract, right? You didn't want to open the CBA. And I agree with you. If it deals with a term or condition of employment, or it explained, more in our case, we were explaining what was meant or clarifying what was meant. And we said, this is how we agree what it means. Now here they're giving a new benefit, but just because they didn't open up the contract, but they do it by some other means, right? That's the really interesting issue. And I would agree. I think even if the court reviewed this de novo kind of fresh and saying, we don't care what the arbitrator said, we're going to just come up with our own answer, I think they would have reached the same result.
Yeah, I think so. And the whole issue of whether or not something is bargainable, whether or not it's a management prerogative, reasonable minds can differ on that. And in particular, if you're sort of pro-labor, you view things one way. If you're pro-management, you view things a different way. And I'm friendly with attorneys on both sides. I try to keep my relationships clean with both sides of that. But you put those two together, and it's like oil and water. On what's bargainable and what's not.
And look, we're the Monday morning quarterback, but we get to take a nice neutral view. And I have an impossible time believing that when you're talking paid leave, right, and continuation of mandatory benefits, that right. It is not a mandatory subject of negotiation.
Yeah, that's a good 50,000 foot view perspective, regardless of which side you're on. It pretty much fits.